and tenants. Throughout the review, we have received roughly 300 responses to our call for evidence from a wide range of stakeholders, including private landlords, estate agents, businesses, charities and tenants, both through a dedicated survey and public engagement events held across the island. Today's hearing will allow the panel to raise its final questions with the Minister for Housing before concluding our work and preparing our report for the States Assembly. And I would like to draw everyone's attention to the following. This hearing will be filmed and streamed live. The recording and transcript will be published afterwards on the States Assembly website. Please ensure that all electronic devices are switched to silence. And for the purpose of the recording and the transcript, I'd be grateful if everyone who speaks could ensure they speak clearly into the microphone. So first of all, I'd like to start with introductions. My name is Deputy Hilary Jearn and I'm the Chair of the Environment, Housing and Infrastructure Scrutiny Panel.
Deputy Tom Coles, Vice Chair.
Deputy Alex Curtis, Panel Member.
Deputy David Ward, Panel Member.
Yes.
Deputy Sam Mesick, Minister for Housing.
Natasha Day, Head of Strategic Housing and Regeneration.
Tim Miller, Policy Principal in the Strategic Housing and Regen team.
Thank you. And today with us we have our independent advisor who has been helping the panel with our review and who will be providing us with the report after this meeting in the next few weeks. And so,
Chair, thank you. My name is Michael Tomlinson. I'm a barrister practising at 3 Paper Buildings and I've been appointed by the panel as an independent advisor.
Thank you. And Michael, we would ask to come in at certain moments if there are any questions that he would feel that he would like to ask after hearing the Minister's responses. We have 2 hours for this meeting. We have a lot of questions, Minister, and I'd like to kick off with the first one. Within your common strategic priorities, you committed to deliver a new residential tenancy law to improve arrangements for both tenants and landlords. And though the principles of the draft proposal, though, says a law to amend the Residential Tenancy Law 2011, including to improve tenants' rights under residential tenancies. Given that the draft law is intended to improve conditions for tenants, why were landlords not also explicitly included within the principles, particularly if, as I understand it, you believe the law is also improving for landlords as well?
Mm-hmm. I think that's political nuance, and I kind of think it goes without being said that if you're providing a better rental market, then good landlords will automatically benefit from that. I think it's axiomatic that if you are providing clarity for how tenancies can be managed, and importantly how the trickier circumstances can be dealt with, like asking a tenant to move on, then that clarity and certainty also will extend to good landlords. But I do have to make the point clear that a big part of the law is, or a big part of the point of the law is to try to tackle some of the poorer behaviour that I do see on a day-to-day basis.
Thank you, Minister. And going specifically into more of the areas around the amendments, the draft residential tenancy proposes a rent stabilisation measure that will cap annual rent increases to no more than 5% or RPI rate, whichever is lower. The panel has received considerable evidence from members of the public, local organisation and key stakeholders expressing concern that the proposed rent cap could negatively affect the private rental market, potentially leading to a reduction in rental housing supply. How do you respond to these concerns, Minister?
I think that what's proposed is about as moderate as you could possibly get in the form of any kind of interference in how rents can go up during residential tenancies. And I think a point that doesn't seem to have been understood by some who've commented on it is that these are passive proposals. They're not like what exists in other jurisdictions where if a landlord wants to raise their rent, they have to go and ask permission from the government to do so. This is to be in the first instance dealt with by landlords and tenants as they see fit, but with a safeguard that if rents are to increase above those caps, then at that point a tenant has a right to appeal it, and that appeal is based on 2 specific exemptions to that cap. My view is that by putting that in law, by and large, people will just get on with it themselves without needing supervision on it and be fine with it. And when a landlord needs to propose that rent goes up by above those amounts because properties rent has fallen well behind market rate or the landlord has invested in the property, etc. By and large, I presume that tenants will be accepting of that because they'll be able to see with their own eyes that what the landlord is trying to do is legitimate, and that if they try to appeal it, if it's clear that the landlord is in the right, well, their appeal's not going to stand any chance, so that there would be no point in going ahead with it. The only times that it would, that a tribunal would side with the tenant is if the landlord has attempted to raise rent at an unjustifiable rate when they haven't put that kind of investment in the property and the rents haven't fallen behind market rate. And I kind of think if you as an individual landlord have a model that is based on raising rent at unsustainable rates for your tenant without putting that investment in and without basing it on market rates, then that's not really a model that we want to be supporting.
Thank you, Minister. And if the draft law is approved and landlords choose to exit the market, causing a contraction in the private rental sector, as they have talked about, what monitoring mechanism will the government put in place to track the effects on tenants and remaining landlords, and what mitigation strategies will be available to address any resulting shortfall?
Well, the first thing to say to that is that we have, if landlords are exiting the market, those homes don't disappear into thin air. They can be bought by other landlords who are perfectly happy to deal with these proposals, or they can be bought by people who are aspiring to own their own property that they live in. Both of those are good outcomes. The ways that we can measure this are twofold. Firstly, we have the rental dwellings licensing scheme, which is relatively new to Jersey, that we didn't have previously, and so we would pick up through that when licences aren't being applied for, where they previously have done. And of course, we also now have the we have the stamp duty surcharge, which means in the raw court transactions, we are now picking up when a transaction is by an investor. So we can track how many are being bought by new landlords or existing landlords adding to their portfolio. And those sales going through that, we can track those as well.
Thank you.
Sure. I've got two questions. Just one to go back on to the first point about the 5%. Do you believe there's a risk by being explicit with your 5%? Do you think that actually, because you're being explicit, that has actually introduced risk into the market and is why landlords are concerned? I appreciate all the arguments you've made, but the fact that you've been explicit with a number, does that not concern you, the response that's been given to us?
No, I think the onus would be on them to justify why they would have the right to put rent up by very inflationary rates when they're not investing in properties and rents in their properties haven't fallen behind market rate. I think the onus is on them to say why that's a justifiable practice.
Okay, all right. And the second question is really around the contraction in the market. I know you say, well, a new landlord may well come in and take over the property, but obviously in the meantime, you have this situation whereby someone has to vacate the property, the property becomes vacant. What happens to those people who are tenants? They've got to go and find another property before the property is sold, and so you have this gap between buying and selling, which makes people effectively homeless. Is that not of concern to you?
That happens every day already under our current system, that a landlord's entitled to sell a property and seek vacant
But the
possession.
concerns in this is the risk, and which what you could say is if you saw more people doing this, you could end up with a bigger homelessness problem.
If there's a massive spike in properties being sold, then we'll see lots of transactions and we'll see lots of movement in that time. I personally don't buy it that will be the case, especially given there are transitionary measures in this law that will allow existing tenancies to continue as they are until they naturally expire, and then they can be renewed onto a subsequent new initial term. So that before the full brunt of the proposals are felt by some landlords, that's going to take years in some instances for that to be the case. So I simply don't believe the doomsday prediction that there's all of a sudden going to be a massive spike in homes on the market, especially when we look at the state of the market at the moment, where house prices, particularly for small homes, have come down in recent years by the biggest amounts that they have since records began, which means that's actually quite good for those who are wanting to buy their first home. So with every challenge, there's also opportunity, and we may well see some tenants be able to become homeowners if there's more properties on the market and prices coming down.
Thank you, Minister. And the panel welcomed the publication of the policy paper underpinning the proposed rent stabilisation measure. For the benefit of the public, Minister, could you briefly explain why this specific approach was chosen?
Well, I don't think it would have been completely right for me to have dreamt up some system and imposed it and said, this is down to my brilliance and I promise you it will work. It would be right to test it and be right to look at what options there were. When I started this, I wasn't 100% settled on what I thought the exact right mechanism would be. I wanted it to be credible, and I wanted the views of others to input into that process. And so I think by going through a multi-stage process involving the economics unit, looking at some options, re-looking at options once other things had been considered into that, I think ultimately meant I had greater confidence that I was picking a version that I felt would do what it needed to do for Jersey. And I did fluctuate in my position during that process because of what I was reading in front of me, and I didn't start with one position and end with exactly the same position without moving in between it. I took in all of it, and that was very useful to me.
Thanks, Minister. The draft law includes the power, Article 24(1)(1)(b), to be precise, to specify a different maximum percentage for annual rent increases, which we understand is intended to allow the state assemblies to raise or remove the 5% cap in periods of high inflation. However, the provision is not limited in that way and appears broad enough to also permit a reduction of the cap below 5%. Can you confirm whether this is the case and whether you envisage any circumstances in which a reduction might be considered appropriate? And if not, would you agree that clarifying this point could provide greater reassurances to landlords?
I think it's a given that if you're setting regulation-making power for the Assembly to adjust that cap, that it cuts both ways. In my lifetime, inflation has been relatively low. When I talk to my parents, they remember it being very much higher than it currently is. So that clause is there as a safeguard, just in case our entire economy and how things work in future years does change or goes back to what previous generations have experienced, and we'll need the flexibility to respond to that as and when it's right. And that's for the States Assembly to do, not an individual housing minister. And what was the other part of the question, sorry?
I was just, if not, would you agree with clarifying this point? It's just, I think it's because the article specifically talks about increase, it doesn't talk about decrease, and we're just saying whether that is clear enough for those reading the law to know that it goes both ways.
Okay, I don't have that particular article in front of me. Does it specifically say?
It says amending Article 7A to specify a different maximum percentage at which the annual increase in RPI is capped, and then in brackets for limits on rent increases during the total duration.
Okay, yeah, I think that's clear. It means either way.
Okay, thank you. The draft law does not currently include a statutory review to reassess the effectiveness of the rent cap over time. And given the potential for economic volatility or worsening house pressures, has consideration been given to including a formal requirement with a periodic review of the rent cap's impact?
No, I haven't considered that, no.
And why not?
I don't believe it's necessary. I think that this is something that would naturally happen anyway. Honestly, I don't think it's particularly useful for the public sector generally to artificially hold reviews on things when everybody kind of knows they don't need to be reviewed and everything is fine at the moment. I think it would be a better use of our time and resources to address that kind of thing as and when it appeared to be an issue that needed to be addressed. And I think a tick box exercise may not necessarily be the best use of resources.
And so when either the minister or a member of the State Assembly would be proposing this increase or decrease with the RPI, would that be the moment then to basically provide evidence for that? Because of course.
Well, yes, definitely. You would have to if you were putting forward those regulations. You would want your report to that to be as robust as possible. But it might also cut the other way in that if there was a suspicion that this metric was out of date at that point, you might unilaterally want to decide to do that review before concluding whether regulations needed to be brought or not. And you might do that exercise and say, actually, no, it is fine, and let's not bring anything to change it yet. So you could cut either way there.
Minister, Article 7D allows a rent increase above the cap either because the current rent is significantly below market value or because the landlord has made investments with benefits to the tenant, which you have said already. Do you consider the present wording sufficiently objective for both tests, and what criteria or guidance will ensure these judgments are applied consistently?
Well, the guidance will be the key part to that. So once it's settled one way or another, whether the Assembly is happy for this proposed system to come into force and whether it's happy that the rent tribunal in the form that it's proposed is appropriate for the island, then before the commencement of all of that, it will be our job to put that guidance together. That will mean consulting with people who are, potentially wanting to use the system to try to make sure it's as clear as possible in that. And we will have time to do that before this comes into force. So there will be a period where we can bring people in and look at that and say, does everyone agree that that's clear enough to proceed with? And then I make the judgment to proceed at that point.
And would this guidance be updated as and when as the law is rolled out?
I would presume so, because at this point we have absolutely no idea how much the tribunal would be used, and ideally it wouldn't be used at all. But you never know. So I think after a period of time of cases going through, it would be right to assess the success of it and whether anything does need to be tweaked on that basis.
And before we head to the rent tribunal questions more specifically, the subcommittee of the Jersey Law Society raised a question about introductory or concessionary rents, and some landlords have a reduced introductory rent for initial period, say 3 to 6 months. The 5% cap would pose a barrier to landlords having such an introductory rent. What do you have a view? Do you have a view on this point?
I personally don't hear much feedback about that as a standard offer in tenancies. In fact, honestly, I can't recall hearing of one instance of that. Has that come up?
Well, we've seen the feedback, and I've certainly considered it myself. I think we'd have to seek some law officers' advice to be sure, but if it was contractually bound by the expected rent for the life of the tenancy, that is the rent, and if a landlord decided to offer some form of discount on top of that, I can't see that the law prevents that from happening, as long as the rent is recognised as the full rent in the tenancy, and then the rent could go to that amount. So we're very happy to double check that interpretation, but that's how I would have interpreted that in that scenario.
Thank you.
Okay, Minister, moving on to the Rent Tribunal. And during your recent public hearing with us, your officer confirmed that the actual rent data collected through the licensing scheme as part of the provisions in this law will not be provided to for use in individual disputes to the tribunal, at least not in raw form. And given, obviously, a landlord will be seeking to increase rent and having to prove a case, how does a landlord or a tenant or the tribunal assess at the moment, in your view, what's the operating function of the tribunal in the absence of this data?
At the present time.
Well,
So,
in the present and the future.
In the present and the future. So before they have that richness of data for the market overall, we do have some data on the rental market which comes through the house price index, but we know that that's based on advertised rents, but advertised rent is a representation of a market value. The way that we would appoint or seek to appoint the composition of the tribunal would certainly have regard to the skills and knowledge of the tribunal members. So we know that the chair, for example, would be legally qualified because they hold a certain level of responsibility for the implementation of the law. But the lay members, if you like, would be looking for people who have property experience, who could make a well-qualified judgment on the market rent. But it depends on what part of the law the appeal is drawing from. So, in the case of has your rent gone up more than once per year, that's a very straightforward situation. In the case of improvements to the property, it's not just the market value, it's the value of the improvements themselves. And so the tenant would be required to submit so the landlord would be required to submit evidence in relation to what has been invested in, and they can use that evidence to inform their judgment as to whether or not that was a fair rent increase relative to those improvements. I think the market value is an important dimension, but it's not the only dimension that the tribunal members would consider to reach a fair conclusion.
I think you'll have seen some of the feedback we've received has concern about the operation of assessing market value. And, you know, for those who have written to us, how would you describe they could go and understand what the market value of their property would be in a year or 2 years' time? What data is available to them to make an informed decision that ultimately they will have to back up?
Well, they would look at what's currently on the market, what's comparable to their offer, and use their judgment on that basis.
That'd be advertised rents, would it?
Yeah.
Okay. And therefore, do you see comparing, for the case by the landlord, comparing advertised rents to what they would be, obviously creating a transacted rent would be a fair defence in a tribunal?
Yeah, I would have thought so.
Okay. And then really more broadly, where does the value come from collecting rents data if the use of it, at least immediately, isn't going to be of a huge use by the tribunal and it won't be accessible by the landlord or tenant?
Well, it won't be immediate, but it will over time. And this is data that Jersey has collected in the past through previous mechanisms that existed. It's a gap that exists now. And when you look at the Stats Jersey chart, there is literally a gap that they put in to say we couldn't get any data in this part. So it will be slow in the body of data being compiled, but it will get there eventually. And yep.
I was going to say, has Stats Jersey then influenced how you're going to be collecting this data, or are they given it the
Yes.
big...
Yes.
Okay. So you mentioned the composition of the rent tribunal, but in the absence of actual rent data, beyond just qualifications, how will you be able to proactively assure that those members are able to assess consistently and fairly market rents?
Well, we'll go through a process of seeking expressions of interest for people to join that. That won't simply be me picking people randomly. There'll be a process before that. I think the last time there was an attempt to establish a rent tribunal, the Appointments Commission had a part in that. When that was done, there were people who I would have had confidence to have served in that role who'd applied. So I presume that'll be the case next time that people will be forthcoming, but ultimately the Assembly will have the ability to say no if they're not convinced that they're fair and reasonably minded people.
Okay. And more submissions have also, we heard from one body in a public hearing that they felt more data could be collected and this law doesn't go far enough in regards to the level of data. Did you consider, beyond just the fact you want to tie into the rented dwelling licensing scheme, more frequent data collection and both the pros and the cons you would face with that volume of data?
Very much I did consider that. And as you say, there are pros and cons. If we have a more proactive and closer to real-time version, that will involve more bureaucracy, it will involve more form filling and administration and more cost. In order to do that. The body that's calling for me to do it more often is also the same body saying there should be less red tape. The version that I'm proposing is the one with the least red tape. It will do the job and will do so with minimum intrusion, and my judgment was that that was the right balance to take.
Okay, and is it the plan that collection of data every 2 years collects the rent data for that year, or would it collect the rent data for the last 2 years prior? So, albeit in retrospect, you would have yearly data.
Good question. I hadn't considered that, and so we'll consider it.
Yeah, we're going through probably a similar process actually as to what we did with the rent controls metric, to look at the different ways to collect the data, the type of data, and how that data will be reported. We're working with our colleagues in regulation who would ultimately take on the role of managing the data collection, and working really closely with Statistics Jersey because they will ultimately report on the data. So there's a lot of fine tuning that will come in terms of how and what, and the law enables us to define that through an order later on.
Okay, great. Turning to some of the comments made by the Judicial Greffier in their submission, they note that the tribunal is expected to hear or would have initial capacity to hear 3 cases per month. I was going to ask, was this the estimate provided by your department? But I note, Minister, you just said that you have no idea how much the tribunal would be used. So could you maybe opine on whether that's a reasonable reflection and kind of pre-building of case
It's
capacity?
our best stab at it. We won't know, and that is one of the difficult things in judging these. I believe we spoke to Citizens Advice to get an indication of how often they're getting this kind of thing coming to them, and that helped influence that to try to give a best estimate, but it can only be our best estimate.
And was that an estimate that came from your department to the tribunal service?
Yes.
Okay.
Yes, we work with the tribunal service.
Okay, they did note that the tribunal may need to pause or slow its function if case numbers exceeds expectations. In that eventuality, if that were to happen, what contingency plans are in place to ensure continuity of service for tenants and landlords?
Yeah, I mean, so we'd have to continue to work really closely with the judicial greffier, and we've built quite a good working relationship with them. I think in the early days of the tribunal being functional, we would have to monitor it very carefully, but of course there'll be a softening of the use of the tribunal because of the transitional provisions that will take some time to filter through. So we don't expect it's going to be a case of the tribunal becoming established and then becoming overwhelmed with cases. At the very least, the transitional provisions is going to soften its use over the introductory years, if you like, of the law. And so therefore, we should start to see it with good foresight that the use of the tribunal is increasing, and we could work with the greffier to develop any additional business case that may be needed to increase the capacity of the tribunal, which may mean appointing additional members and holding additional sittings.
With regards to, you mentioned the softening of the use, what evidence do we have to suggest that that is how the creation of a tribunal would work?
Well, it's the transitional provisions that slows the entry into the new provisions.
Okay, has any consideration been given to often when new bodies are formed for recourse, they often do get used? I think about the statistics the Commissioner for Standards has seen in Jersey that actually she, I think, described the immaturity of those using a new service often go to it in quite large measures, and we saw that statistically. Has any consideration been given to a risk that a new body available to people would actually cause a larger number, basically because they're learning about the system?
Well, to be fair, we're setting up a tribunal, and my hope is that it isn't that necessary. But if it is necessary, I want it to be used. I want tenants to feel empowered to be able to go to this tribunal and say, I'm suffering an injustice, and please rectify that for me. So I want people to use it if that's what's right for them. But I would reiterate the transitional arrangements do mean that on day one, you don't all of a sudden have every tenant in Jersey eligible to use this tribunal. It will bed in over time because of how those tenancies will then proceed.
Okay, great.
Is there going to be a mechanism, or have you established with the judicial greffier that if somebody's initial submission for the rent tribunal indicates that they haven't exceeded the RPI for the year or the 5% cap, that actually it will just be dismissed at that initial point?
Well, if they were bringing, sorry, are you saying?
So it's about the process, about how you're getting into the rent tribunal, because assuming it's not going to be something you can just turn up, it's going to be having to make submission of evidence and things like that. So the rent, is the judicial greffier comfortable with the fact that they will be able to just say this is a vexatious claim and dismiss it straight away before it gets there?
Yeah, I mean, it might not necessarily be vexatious, it might just be naive, but I mean, it's not going to go to a full hearing when it's absolutely clear and obvious that what's being challenged is actually completely compliant with the law.
But are they going to have an administration team that's going to be allowed to do that? Because, I mean, we've been talking a lot about setting up the tribunal itself and its membership, but actually there is going to be a lot more paperwork to be done behind the scenes to make sure that this tribunal isn't sitting full to the brim every single time of people who are challenging a 3% increase when RPI was 3.5%.
Yeah, I mean, this is something that we have discussed with the judicial gref. We'll be looking to make sure that application forms have a natural ability to filter through when somebody hasn't actually experienced a breach of the law or something that could cause for a legitimate claim to the tribunal. We're still working through what those forms look like and how far they can go in terms of filtering out those cases where they don't actually have a legitimate reason to apply to the tribunal, but it's certainly our objective to make sure that we have an application process that is clear and avoids the tribunal becoming overwhelmed with cases that aren't legitimate.
Okay, great. Moving quickly on to the timetable, could you briefly outline what the proposed timetable for establishing the rent tribunal is and how that will work? And specifically, we're keen to understand the sequence of steps, such as powers to appoint tribunal members, when they come into effect, how quickly appointments can be made once those powers are in place. In essence, that timeline, that chain of events starting from now, or an approval of a law to then.
Fine, 9th of July. Does either Tim or Natasha want to take that?
Yeah, well, I mean, I'm happy to summarise. So you'll be aware from our private briefing that given the overall timeline between now and the elections, we are working within a constrained window to establish a tribunal. We made a conscious decision to not include an appointed day in the law, which gives us flexibility to do all of the administrative work and prepare for making appointments. Whilst the law is lodged and pending on when it is fully debated, we'll use that time to work up the draft legislation for the tribunal, which we've already started on the instructions for. And then we would look to sequence the regulations with the commencement of the law. At the back end of time, it is becoming more constrained early next year because we have to account that, even if the Assembly decide to agree the legislation at the beginning of July, we then have to seek royal assent, and that still is a long process to go through. So really, that timeline is at the mercy of the decision-making process and the agreement of the legislation through the Assembly. But in terms of sequencing, we in order to appoint the tribunal members, we have to have a law to appoint them to. So we can do a lot of work, I guess, at risk, if you like, to prepare for that, in terms of like job descriptions, getting the advertisements ready, and we'll press go as soon as we are legally allowed to press go.
So you aim to, in essence, as soon as any piece of secondary legislation comes into force, to like the blue touch paper, basically, and go for it?
Yes.
Okay. Moving to some of the feedback from the Magistrates' Court, Graffier, they raised concerns around the absence of clear time limits for the new residential tenancy tribunal, seeing that this created a risk that the Petty Debts Court will either enter premature default judgments against tenants, or, if it stays the case under Article 14, leaves landlords unable to collect valid increases for months. It has also been identified that the draft law does not expressly state that tribunal awards are immediately enforceable as civil debts. So will you direct the Petty Debts Court to grant an automatic stay of rent arrears claims where, let's take a couple of cases, until the tenant's 10-week window for filing a challenge with the Residential Tenancy Tribunal has expired? I could pause there, actually, if you'd like.
I might be wrong on this, but when I read the submission you referred to, I wondered if they were fully cognizant of the fact that rent increase that the law will be proposing that rent increases must come with 2 months' notice. The way I read it, it sounded like they thought they could come into effect sooner than that, and therefore the moment at which a landlord might want to pursue it in the Petty Debts Court is sooner than that, when in actual effect you wouldn't know that you wouldn't know that a tenant was not paying their rent increase for 2 months before it came into an action. So that does shorten the window in which there would be a dispute as to whether rent that was lawfully owed was actually being paid or not. That might have been my misreading of the submission, but it kind of read that way to me. So that the fact that there's a 2-month notice period for rent severely mitigates that and brings that timeline of events where someone's going to challenge a rent increase and not pay it in the meantime is, I think, shorter than what I read it as them thinking it might be.
Okay, and can you just clarify for us, just for those listening now, what time frame that one who wishes to challenge that rent would be? So do they have to challenge it? What's the time period again? Within
2 months and 2 weeks from the point of it being issued, the notice being issued, so not it being enacted.
So under that, there is a scenario where somebody could have 2 months' notice and choose to issue a claim to the tribunal 2 weeks after even the date that it should have been enacted.
Yes, yeah, that's right. And so there is an overlap, and that will be uncomfortable for parties, but there often is discomfort in these things when people have to go to a body to make an appeal, and in the meantime things aren't great, for one party at least, in that. But the fact that that overlap is relatively short, and hopefully the tribunal being as busy as I hope that it will or will not be, would mean there won't be prolonged periods, and you shouldn't really be going after rent for someone like a day after it's due. The first instance should be to have a conversation with the person and say, what's going on here? Is everything all right? And investigate. You shouldn't really you shouldn't put your application into the Petty Debts Court on day one of that. You should investigate things in a inquisitive way and hopefully compassionate way before that.
Okay, so it's really actually a 2-week window you're looking at between a realistic chance to take you to the tribunal once the rents have been enacted, given the 2 months, the 8 weeks prior.
Yeah.
Okay. And then, secondly, on to when a challenge has been filed, is there going to be directions from yourselves as Minister as to how to handle a stay on rent arrears during that period during that period up whilst a decision's being made and then ultimately decided on?
Yeah. Do you want to take that?
Sorry,
That's us. You're saying us directing the petty debts?
Well, no, the Petty Debts Court have shared a lack of clarity over some of the operations.
Yeah.
In particular, one area would be there for how to handle those who are in rent arrears when the tribunal is kind of adjudicating yet not decided, or when a case is sitting in the tribunal's backlog.
Yeah.
So.
Yeah. Well, I mean, if it depends on what kind of rent arrears the tenant is in. If they're in complete rent arrears, i.e. they have paid no rent for a period of time, then that's clearly an issue that the Petty Debts Court would want to be considering. If it's, I guess, as a result of the provisions that you can apply to the tribunal, we're talking about the difference between the rent and the rent increase. So it's quite a insignificant amount in the grand scheme of things. And if there was an accrual of rent arrears, that is going to be an entirely separate matter, and a matter which the Magistrates Court, the Petty Debts Court already deal with. So I'm not entirely sure what the lack of clarity is. The reason why I was slightly multitasking there is just pulled up the Magistrates' response to the panel and note that overall they don't have any particular concerns and that they welcome the provisions that it kind of removes that pressure from them.
Yeah. Okay. One area that I did mention that I would like to almost kind of round off on this part, which was around any specific clarification as to whether those tribunal awards are immediately enforceable as civil debts. And so a question would be, do you recognise that as a challenge within the law, or at the moment that tribunal judgments on where a rent increase was justified are not immediately or directly defined in the law as a civil debt? Is that something you think is fine as it is, or is there work required to be clearer? And ultimately then, how does somebody who should be in receipt of those debts have clarity when they go to the petty debt to claim what could be 3-4 months of additional rent arrears?
So, I mean, my interpretation of that, and forgive me, Tim, if you wanted to come in, is that the provisions of the law would already apply, and it is a debt.
It is a debt, and there is no kind of softening power over the fact that it's a debt that appears at one point. So, if a tenant took a case, was it unsuccessful, the day after, ultimately, the landlord could pursue it in the regular means of any civil debt.
Yes.
Okay. Okay, these are good. We're in a good meaty topic section, aren't we? So finally, what consideration has been given to the fact that accessing the rent tribunal requires a tenant to bring a case against their landlord, potentially reinforcing an existing power imbalance?
Very good question, because there are places where it's different. I think it's different in Scotland, where you have to, if you want to raise rent by a greater amount, you have to proactively apply for it, whereas ours is permissive and passive. That's my judgment, that the appropriate model for Jersey is not one that is hands-on and deeply involved by the tentacles of the state into people's contractual relationships there. I think a passive version is better for that. When you combine the provisions for rent stabilisation and a rent tribunal with the periodic tenancy changes and the abolition of revenge evictions through those mechanisms, those combined, I hope will leave tenants feeling empowered to know that they can stand up for themselves when they're treated unjustly, and they can avail themselves of the rights that they do have without having to worry that they will just get a no reason or no fault notice issued to them, which the current law absolutely allows for, and it's one of the reasons, in my view, that previous attempts to reintroduce a rent tribunal were flawed, because they didn't come with those protections alongside them. I hope that once those things bed in, that will start changing the culture in renting, where people on the wrong side will know, don't bother, because the law is more robust now and you won't get away with it. And on the other side, if a tenant is treated unfairly, will know that their chances of being unjustly kicked out of their home for standing up for themselves are drastically reduced under this.
Okay.
Yeah, just that wording you've used, which is pretty emotive, abolition of revenge evictions.
I don't consider that emotive at all, it's factual.
Okay. You think the concept of revenge eviction, I appreciate your political language on that front. But could you just explain what you mean by the abolition of revenge evictions?
Well, the fact that landlords will be required to state a reason why they're issuing notice will mean that illegitimate reasons will not be able to be considered for that, and if they attempt to use a legitimate reason dishonestly, there'll be punishment for it. That is different to the situation now, where notice can be issued at any time for any reason. There's no right of appeal. Tough luck, you're out. That simple safeguard, which in most instances will amount to nothing more than another sentence in an email, is, I think, a very proportionate and effective safeguard. So unjustified, illegitimate and revengeful purposes for issuing notice, that there simply won't be room for it in this framework.
Thank you. And at this point, I'd just like to see if the advisor has any...
Chair, may I just come in on one point, if possible? Minister, you said, just talking about the 5% rent cap, and clearly you've seen and read the concerns from landlords in that regard, and so you've provided that there will be a regulation making power where that can be raised or increased. Just coming back to the Chair's question about that to you, you said that on a plain reading of that, it could go up as well as down. I think the point is, would it not be more reassuring to landlords if it was drafted differently, so it would just go up, and that's the reassurance that actually the cap can be raised, but actually we don't envisage a scenario where it would be reduced?
I apologise for my language here, but I think that would be pandering to that worry in a way that I just don't feel comfortable going that far. I think that, I hear the worry, but I don't think it's justified. And I think that the law having the balance to go up or down is right. That, some people won't like that and would want it to only go one way, and that, that's fine for their view. But in the first instance, we're starting off at a very transparently proposed system. It'll be down to future assemblies to decide if that needs to change. And I wouldn't want to not give a future assembly the opportunity to look at it from a different angle, because we don't know what economic circumstances will look like in years to come. So I would prefer to reassure them on the basis of what we've got than to change something to seek to reassure them, and no doubt I'll probably fail to do so for some of them anyway.
Chair, thank you.
Thank you. So moving on to periodic tenancies. The intention of the draft law is clear, that periodic tenancies rather than fixed-term tenancies will become the norm, but there is a possibility that the norm or the default will rather be an initial fixed. No, sorry, I'll start again. There is the possibility, from what we've seen from the landlord's responses, that the norm or the default will rather be the initial fixed term. Is there anything that you are doing, or anything that you can point to in the law, that will encourage the periodic tenancy from the outset rather than the initial fixed term?
No. If you look at other systems and the English Renters' Rights Bill, they're not even bothering with initial fixed terms. They're going straight to periodic. I think that there's actually a fair argument for that. The only reason that I'm including an initial term tenancy in this is to provide some kind of reassurance to those landlords who are concerned about the transition into periodic tenancy. If I had less regard for what they thought, I'd have just gone for periodic tenancies, but I do have regard for what they think. So the initial fixed term is an attempt at some kind of balance to give confidence as we move towards periodic tenancies. I think when they become more widely used, their benefits will end up feeling obvious to both sides, not least the, not having to go through those processes of renewing tenancies and renegotiating and all sorts that can come with that. I think over time it will be seen that actually they're quite easy, and the fact that you can't renew a fixed term into another fixed term, so they will have to become periodic. People will experience them now over time, and they'll realise that there's nothing wrong with them.
Okay. Do you consider, or has the risk been with this maximum 5% cap or RPI and the fluctuating market values, that we might find ourselves in a scenario where actually there is a larger turnover of tenants where everybody's only doing this fixed term, exiting the fixed term at the end, and then getting another fixed term with a new tenant after that. So actually we all see a higher turnover of people in accommodation rather than actually people getting a more prolonged home.
If that's a model that some landlords choose to adopt, I would regard that as cutting your nose off to spite your face, because the process of getting rid of a tenant at the end of a fixed term and getting a new one involves costs. It involves a void period where the property's not making any rent. It involves having, potentially to renegotiate terms of a contract if you were struggling to find a tenant at that point. And even though the initial term can be for up to 3 years, I don't think there'll be that many tenants who'll be keen to bet on moving into a place to live their lives from contractually for 3 years when they don't actually know if it's going to be suitable for them. I think they'll struggle to find ordinary tenancy agreements where tenants are prepared to put up with that. It will probably, in practice, be much less than that. It just strikes me as so illogical for your business model to get rid of a tenant because you don't want to be bound by a periodic tenancy in which you've got all the rights you'd want to have anyway to get rid of a tenant if there's a problem or they're causing difficulties with the property. So it strikes me as cutting your nose off to spite your face.
And on that subject, we've had through submissions and discussions of ourselves that there seems to be that the notice periods has changed so that once you enter the periodic tenancy, you get this notice period where you basically are living on a 3-month notice period rather than when you had a fixed term 1-year lease, you basically with the 2-month notice period or even the new 3-month notice period, you've gone from having 9-month notice that this is your home now to only living for a 3-month notice period that this is your home.
Mm-hmm. Indeed. So let's be clear that security of tenure is not just about the security to stay, it's also about the security to leave if your circumstances change and a home ceases to be appropriate for you anymore. For a tenant to be tied into a contract, a fixed term contract that may have months and months and months left to go, years potentially even left to go, poses risks to the tenant as well. And I can give you multiple examples of how this kind of thing can manifest, but a really clear one I encountered recently was a couple who renewed their tenancy for another year, and a month into it they broke up. The tenancy was only in one of the couple's names, and she suddenly found herself contractually liable for 11 months worth of rent that she had anticipated paying on 2 incomes and was now having to pay for it on 1 income. And when she asked to negotiate her way out of that contract, the landlord insisted that she paid over £1,000 to be able to do that. That can be devastating to somebody, and whilst it would theoretically have been nice to have the certainty of a fixed-term contract, which is certainly what this person thought in that instance, it came back to bite them because they didn't have the security to leave when was appropriate for them. But just 2 other points to add into that. I am seeing, I'm having people come to me and show me tenancy contracts that are fixed-term tenancies that have break clauses in them that are one way, only for the landlord, and are no fault. I'm seeing fixed-term tenancies come to me saying this is a 12-month contract, but the landlord has a break clause where they can kick you out in 3 months' notice for no reason, which doesn't apply to the tenant. I would call that highly unbalanced there, I'm seeing that existing. But even in a fixed-term contract, a landlord can still seek an eviction if you're breaking the terms of the contract, you're not paying your rent, or damaging the place, etc. So even in a fixed term, there's still ways of getting rid of a tenant not providing them security that you would think they would have. So I really think that the extra security of fixed term is really over-egged.
Yeah. Could I quickly just check on what you said, Minister, there, which was the example of contracts coming to you which were unequal to the landlord, giving them a break clause but not the tenant.
Yeah.
Is it your understanding that as drafted for an initial period under the new law, the 1 or 2 years, the landlord would no longer be allowed to put that clause in? Is that a function of the law, or could that still occur under the new law?
They can still be break clauses.
They could still put a break clause in under the new law, but for your word, for any reason?
Can you remind me?
Yes, so that's we're introducing a mandatory requirement for the break clause terms to be specified, and that is with the Minister's objective to ensure there's full transparency of any obligations on landlord or tenant before signing up to a new lease. If you don't mind, Minister, we are currently looking at the wording of that just to make sure that it gives the full effect, so that we may be coming back just to tweak some of the wording there. But the idea is that the landlord and tenant would have their requirements for a break set out very clearly, and we would support that with clear guidance to ensure that tenants know what they should expect from that. Because, as the Minister said, this is an existing practice where a one-sided break clause may be included, but tenants don't know their right to be able to challenge that and request their own break clause to be included. So given that the law will provide for the fact that both tenant and landlord terms need to be included, we'll supplement that with guidance, and we hope that will vastly improve the practice of the use of a break clause in a fixed term tenancy.
And just to add to that, the two occasions where I've seen that clause in a contract, one was in an existing contract and one was in a draft contract that hadn't been signed yet. And when I pointed it out to the tenant, they went back to the landlord and went, hang on a minute. And the landlord went, okay, fair enough, it's a fair cop, and changed it and made it two-way at that point.
And we'll move on to grounds for notice. That seems a nice little segue. So the panel's evidence suggests that there is a general agreement that the need for appropriateness of grounds for notice by all parties. However, some concerns have been raised about the introduction of the 7-day notice periods for the following reasons: the illegal use of the property, serious or repeated nuisance, employment-based tenancy ends per contract and employment law, loss of work permit, and incorrect housing status. Minister, the panel understands that the rationale for each of the grounds you've introduced a 7-day notice. Concerns have been raised about whether such short notice periods is appropriate in all circumstances, particularly in the cases where the tenant loses their job or work permit and is therefore facing both employment and housing insecurity simultaneously. Do you believe that the 7-day notice period is fair for the periods in all cases?
I do. There are some other safeguards, though. Obviously, when it comes to employment, if it's tied to employment, there will also be an employment contract that will have a process for ending that employment. And if it's for, if it's not for a particular drastic or emergency circumstance, might itself come with further notice. So you would benefit from the notice from the employment contract as well as the tenancy contract. There are elements tied to things like work permits, your legal rights to reside in a property as opposed to your contractual right to that tie in with these. So we did look at these quite significantly to work out what other things they were connected to and how in practice some of that would work. And this is where we arrived at, and I'm confident in that.
Yeah, just to come on that point about those two legal situations, the employment contract and the tenancy contract, which one overrides which? I mean, does one override the other at all?
No, they're separate.
I know they're separate, but I mean, what I'm just saying is if you have a legal document which is within the law of the tenancy, and that doesn't match what your employment contract says. Which one wins, as it were?
The law imposes minimum standards. It doesn't automatically mean maximum standards. So if you have an employment contract that says your notice period for your employment is X length and it's more than 7 days, 7 days doesn't. You will know that you're actually getting more than 7 days because of that. This is minimum, not maximum.
Okay.
Do you have any? No. So generally, Jersey Landlords Association submitted as part of their submission that there should be the inclusion of a provision relating to immorality as grounds for eviction, as is the case under the Housing Act 1988 in England. Was such provision considered during the development of the draft law, and do you have a view whether similar grounds would be appropriate or necessary in the Jersey context?
I didn't consider it, no, because this is 2025, and I think immorality is going to be much more subjective. Having an affair is an immoral thing to do. We're going to give landlords the right to kick people out because of their personal relationship issues. Come on.
So Minister, the draft law appears to presume a functional and cooperative relation between the landlord and tenant, even in cases where serious or repeated nuisance or a breach of tenancy has occurred. Could you explain how you intend to support the landlord-tenant relationship through the complexities of the new legal framework, particularly where the trust has broken down?
Sorry, Deputy, would you mind saying that question again?
So it's around the cooperative and functional relationship between a landlord and tenant. How are you going to support that relationship through this new legal framework?
I think this legal framework is helpful because it lays out reasons for notice being issued rather than it being able to be done on a whim or done for no reason or done for revenge. The fact that a tenant cannot simply be kicked out for no good reason, I think will mean that landlords will know that if they have plans for a property or they have aspirations or ideas for whatever, that it's in their interest to have a good relationship with their tenant, to be able to talk things through. The fact that notice period for a tenant will be 1 month, which is right, and that should be the case. It'll be in a landlord's interest to understand what's happening with their tenant. Do they have hopes and dreams? Do they have long-term plans for where they want to go through? It may be that a tenant is looking to buy a home, but that will take more than a month or what have you. It's helpful for a landlord to know about it, just to have an indication, so they think, oh, this might happen at that point. I, in the back of my head, need to be ready for it. I think by its nature, this will promote better relationships and communications between both parties, because there isn't a trump card that a landlord can have with an Article 6 notice where they get everything they want without having to compromise, without having to talk. They just get it all. The fact that as an option is no longer allowed means even when it's for legitimate reasons, as the law lays out, it's in their interest to be open and communicative.
So do you feel that then the law and frameworks would then help balance out that imbalance of power between the landlord and the tenant, particularly when you've got might have a structure where the tenant may have a lack of understanding and knowledge of their resources? So do you feel that this covers it evenly?
Yes, I do. I think that, as I said, the removal of that trump card is a big thing, because a tenant now knows that they can't be punished for doing the right thing or legitimately standing up for themselves. So that means a tenant can have a bit more confidence. And if you've got a bit more confidence, you might even just strike the conversation up. One of the bits of feedback we always hear is because they know they can be kicked out for no reason at any time, that's a reason to not even have the conversation. You don't even want to draw it to landlord's attention just in case. Whereas because you have that safeguard, you're more likely to do it. You're more likely to try and get that mould in the living room sorted out early rather than waiting until you're desperate. Because you're not going to face any comeuppance from it, because you can't.
As part of your work after the principles and legislation been debated, to introduce an easy read guide for both landlords and tenants, so everybody can know their rights in an easy to understand rather than the legalese.
Yes, definitely. We've done a kind of version of that for the purposes of this law, but then we've been cautious about going too much further on that. Firstly, because the law's not been adopted, and secondly, who knows, the Assembly might bring amendments to it that make the guidance I would produce now out of date. So we need to wait for that to settle, but most definitely we want people to understand what their obligations are and have that as easy to understand as possible.
Yeah, obviously because this new law creates the new offence where a landlord knowingly or recklessly gives false or misleading reason for ending a tenancy with a fine of up to £10,000. In the last hearing, you noted that further guidance and codes of practice may be developed over time for clarity when an offence will have occurred. Given this, is there not a risk that the tenant may also be left vulnerable to misuse of grounds for eviction during the interim period before such guidance is in place?
No, I don't think so, because I think in the first instance, firstly, this would only come up once something has happened. And then I would trust the courts to use their judgment and look into every part of the circumstance to reach a fair decision there.
Okay. The panel understands that the Petty Debts Court will retain discretion to grant a stay of eviction where it considers this just, particularly if a tenant argues that a landlord's stated grounds for noting is false or misleading. Minister, can you explain how this discretion will operate in practice once the draft law come into force?
So it's similar to how it already does, because they already have the power to grant a stay of eviction.
Thank you, Deputy.
Yeah, sure. So we move on to fees and charges. In your report, Residential Tenancy Law, The Way Forward, you stated that your aim was to prohibit inappropriate fees and charges, including offences, penalties and appeal rights for both landlords and tenants. However, these provisions do not appear to be reflected in the draft laws lodged. Could you explain why the commitment has not been carried through?
I believe the commitment has been carried through by making all associated fees and charges with the tenancy transparent and in black and white in contracts. Firstly, that will empower prospective tenants to negotiate them if they don't think that they're legitimate. But it will mean that if you are taking up a contract, you by definition have accepted that those are the terms and those are the fees that you know that you're potentially liable to pay. So providing that transparency empowers.
Yeah, I appreciate that, but what about when it comes to increasing those fees? Mm-hmm. So those management fees, those ongoing management fees. So say after 3 months you go, well, do you know what? Instead of paying £1,000 a month, it's going to go to $1,200. Mm-hmm. And how do you?
The contract will have to account for that.
Yes, I know, but I'm saying is there's nothing in the law which says this can't be done by the landlord.
Well, the landlord would stipulate their expectations, so it could be like a percentage increase. An annual RPI, for example, could be applied to a fee as long as that was transparently set out. So the landlord would have to assess at the point of signing the contract whether or not they envisage a need to increase the fee and account for it in the contract.
Okay.
Would it be transparent to say that the fee would go up to the rate prescribed by a property association? In the case of, say, a flying freehold where there were fees associated for maybe cleaning windows were part of it, which would be for the benefit of the tenant, not structurally. Would it be sufficient in this case to say, and the fee shall be at cost to the tenant for that served by the freehold association?
Yeah, I think so, yeah. That's right.
Yeah. Well, I mean, if a tenant were asked to sign a contract that was as vague as that the tenant ought to be asking for that clarity, it would be a much riskier term to agree. But as I said, the minister's taken the approach to not prescribe fees in this regard. That would be quite complex and add a great deal of bureaucracy and limit to tenancies and charges. So again, it's about guidance to the tenant to make sure that they know what to look out for in a contract and where some risky provisions where they may not have full transparency on the potential cost may exist, and we can try to address that, as I said, through additional guidance.
So you don't see this as a loophole potentially?
I don't consider it a loophole, no.
No. Okay. Next question. The report accompanying the draft law states that any finder's fees or similar charges must be clearly set out so that all parties are aware of their obligations. However, the wording in new paragraph 12 to Schedule 1, Article 21.3 may not make this requirement as explicit as intended. Do you agree that the drafting might need to be revisited to ensure, for example, that the amount of any such fee must be clearly stated on the agreement in the agreements?
I couldn't properly answer that without having the article in front of me to know that, but we can give that another look
Okay.
if that's an area of contention.
I was going to say, otherwise, do you accept that the wording may fall short of the stated ambition?
We'll
That's
look
really,
at it.
but have a look at that one, yeah. Okay, next question. Rent as amended by the draft law, Article 3 in the draft law, Article 1 of the 2011 law, is defined as a sum payable by a tenant under a residential tenancy agreement in respect of a period of the residential tenancy under the agreement. Do you agree that the rent is quite narrowly defined, i.e. simply to cover the monthly payments and doesn't cover other fees, service charges or the like? So do you believe that a risk that landlords may attempt, this is my point earlier, to increase other charges such as service fees or administrative charges as a way of circumventing the rent cap? I guess your answer is no.
No.
You don't see that?
No.
Okay. It's a nice, simple answer. So, so you don't believe of any, you've got some clear guidance constitutes rent versus additional charges. That's fine. So we're basically in the no territory on that one. Okay, enforcement. Let's move on to that one.
Deputy Ward, just 2 seconds.
Sorry.
Just because we're ending a specific area
Area, yes, sure.
around tenancy.
Sure.
Wondering if
Chair, may I go back a couple of
Yes, sure,
stages,
sure.
if that's all right? Just very briefly, looking at periodic tenancies and the questions you were asked around there. Clearly, the law, as drafted, stops or prevents there being consecutive fixed terms. You may have seen, Minister, from the Citizens Advice Jersey report, there's a suggestion that if there's a longer fixed term, that might not be a bad idea. So you could then have a consecutive fixed term as long as it was for, say, a minimum period of 3 years. Is that something that you have considered or you would consider?
Sorry, just so I understand the question, is it to renew from one fixed term into a subsequent fixed term?
That's right. You said previously you don't want consecutive fixed terms, but the point from Citizens Advice Jersey is this would still meet the ambition of the draft law of having a longer tenancy period because it would be 3 years or more. Do you have any views on that?
Yeah, I'm against that, and because if you allow one renewed fixed term, you'll then allow another, and then another, and then another, and that will defeat the purpose, because when those fixed terms come to an end, they can be ended for no reason, and that can be, if you know on the horizon you've got a chance to unfairly kick out a tenant, you might stick it out and try to do that. But what I would say is that for any purpose in supporting a tenant's enjoyment of that property, that can be achieved under periodic anyway. So the purpose for which they would be suggesting such a thing, I think, can be dealt with under periodic, so it's just not necessary.
Thank you.
Could I briefly, before we move on, just pick up on that slightly further, which is that any benefit can be secured. Under a long-term fixed contract like our advisor just described, that a tenant could have 3 years of complete enjoyment, regardless to who owns a property, regardless as to any other thing that comes past them. Under your periodic tenancies, a tenant will have no more then, for the first 5 years, 3 months of known enjoyment of that property, because a landlord may die, a landlord may change their circumstances and wish to sell the property or renovate it. Do you consider there to be any challenge that arises from this, what could be considered perceived imbalance, that actually a tenant may think they've got a very long stay, they're going to pay their rent, they're going to pay it to the increases, but at the end of the day, the landlord can issue at any point 3 months for a valid reason, which is not the same as a 3-year tenancy where they know they can invest in carpets or gardens.
Yes, but I go back to the point I made previously, that comes at extreme risk to the tenant, where they can be put in a very, very difficult circumstance if it transpires that the rest of that contract is no longer appropriate for them. They can be forced to pay all sorts of extortionate fees. And it actually doesn't grant them absolute security of tenure, because there are still ways of ending a fixed term tenancy early anyway. So, even in a fixed term, that there are still circumstances where they can lose that home anyway. So it's not an absolute.
How can they, what would be an example of that? Where a tenant and landlord have no break clauses, what mechanisms could they lose their home if they?
Well, either party can apply to the Petty Debts Court to seek the end of the contract, and they can provide reasons for that, and it's down to the Petty Debts Court to decide that. There may well be circumstances that the landlord didn't foresee coming. That means they, I'm struggling to think of what they might be, but they may want to test that in a court and seek for that to happen. There can be things that happen in that time period that are extremely stressful for a tenant. They might not mean losing the home, but can be stressful. It could be a landlord dies and the property is inherited by their 7 cousins. who are now having a big argument over the management of that property. That then filters down to the tenant. That there are things that can happen that will disrupt the tenant's enjoyment of that property, even in a fixed term.
Okay. Can I just to clarify on that as well? The use of the break clause under the fixed term are set to become mandatory. It's the conditions that are down to the landlord and tenant to agree. And the reason for that is because even if you say somebody decides not to have a break clause, well, these situations arise without any expectation that they will. You may think that you're going to have a settled 1 year, both landlord and tenant. Something unexpected happens, and then you find yourself in a situation where very short notice is given, or in the case of a tenant, they are asked to pay several months worth of rent and a finder's fee and charges on top of that. So what we're asking is for people to plan ahead for the eventuality of a break needing to be executed, but that is unlimited. So in the cases, on the one hand, you're making it much more clear to a landlord and tenant as to what they should expect in that eventuality, but the reason for that is still down to the landlord and tenant. Whereas under the periodic, the security of tenure comes is that the reasons to end a tenancy become limited.
Yeah, I mean, I'm just sort of thinking about the red tape on this side of things. So basically, if you introduce break clauses into a fixed term, surely that's the equivalent of what you're doing in a periodic tenancy. Isn't that the same kind of general principle? Periodic tenancy is 3 months rolling or whatever. If you put break clauses into a fixed term contract, then you are giving that flexibility within the fixed term. Aren't you just kind of doing a double whammy here?
They're negotiable, though. That's the point.
Yeah.
In a fixed term, they're negotiable.
Yeah.
Whereas in a periodic, they won't be.
Only that they won't be because there is a list on which to back up the reasons why you end a periodic tenancy. Okay, all right. Okay.
Let's go enforcement.
Sorry, yes, enforcement, yes, sorry.
Looking at the time.
Get stuck into this. Okay, so this is quite a wordy one. Okay, so Article 6G brackets 6G2 brackets N of the draft law introduces a distinct ground for eviction based on a tenant having committed a serious or repeated nuisance. The Minister for the Environment has confirmed that the draft law will change the evidentiary thresholds for which officers would investigate. He noted that the change to a serious nuisance enables action based on single significant incidents rather than requiring a pattern of behaviour, which lowers the evidentiary burden for landlords and officers. He also noted that the revised language aligns more closely with the civil nature of tenancy enforcement, where decisions are based on the balance of probabilities rather than criminal standards of proof. This clearly lowers the evidentiary threshold and shifts the test towards a balance of probability standard. Was that reduction in threshold a deliberate policy choice?
I'm not sure I regard it as that, to be perfectly honest. I think that under our current system, you talked about a balance of probabilities. Well, under our current system, you don't even have to consider probabilities. You can just make it up and issue an Article 6 notice. So that by putting that in this with its conditions, that's raising the threshold at which that could be used as a ground for issuing notice.
Okay. Next question. The Committee Comptable has raised concerns about the potential impact of this provision on the honorary police, particularly where the draft law requires a police officer or regulatory official to have attended the property in cases involving alleged nuisance or illegality. Minister, do you anticipate that the honorary police will be called upon to support enforcement under the provision, and has any assessment been made of the resource implications for them or the parishes more broadly?
Well, it's my intention to follow this law up with regulations that enhance the powers of housing and nuisance teams so that they could take up more of that and be more proactive in it. They're the specialists and the experts in this, so that is where it ought to be more focused on, and that would be the point of those regulations when they come.
Yeah.
Okay.
It's also important to be clear that nuisance exists and there's already statutory nuisances legislation. So if there is a case of serious nuisance or illegality, these services are going to be called in anyway. It just means that in the event that they are called in, that then is clearly aligned to the ground to give notice. I said it's not, this law isn't going to increase the behaviour, it's just aligning how that behaviour is assessed and judged in order to end a tenancy in a sort of reliable way, if you like.
Okay. All quite west in front here. Okay, next question. Minister, the panel understands that the Housing and Nuisance Team is expected to develop a standard operating procedure to support consistent interpretation and application of the new nuisance provision, including model clauses and examples for landlords. Could you outline your understanding of how this SOP is being developed? Have you been consulted in its design, and what key elements do you expect it to include to ensure fair and proportionate enforcement?
Well, our team is well plugged into all of that work.
Yes.
Yeah, okay, fine, thank you.
Can I just
Yes, sure.
maybe thinking about your last point on the nuisance and serious and repeated nuisance, and of course the team, housing and nuisance team, spend a lot of time in the background going and doing a lot of monitoring, and they have the 4 E's, which now I've forgotten. It's like engage.
Yeah.
Apologise. This went very quickly through this question in my mind. Where would the point be in that kind of investigation of the housing and nuisance team to, they often now go through this long process of gathering evidence. How would they, and often that is behind the scenes, it's usually done to ensure that there is that balance for both the one who has reported a potential nuisance and those who are being investigated, because of course the sensitivity of it. How would the housing nuisance team engage with the landlord, for example, on this? Like, where would they come in to be able, because when would the landlord know that it was the point of being able to say, right, well, this is, there's enough evidence here to be able to do the eviction, to do a notice. I'm just trying to think of the order, because you have, if the housing nuisance team starts an investigation, would the landlord have to wait to the end of that? Or?
It probably depends on the nature of the nuisance. So I think as a team we've discussed the example of a tenant having a party or repeated parties that cause noise disturbance, which is a nuisance. That if the landlord were to engage with the housing and nuisance team, that would take a while to build up an evidence that this is a repeated behaviour that could be regarded a nuisance, and that reason under the law applied. But if the landlord has explicitly stated in their contract there are to be no parties, this then actually becomes a breach of tenancy agreement, which would require a different reason or enable a different reason under the law to be given to give notice. So the landlord would have to consider their options relative to the nature of the breach, what their contract actually said in terms of expected behaviours of the tenant in the property. So not every nuisance may lead or necessitate officer involvement to qualify that nuisance if it's a clear breach of tenancy. So I think it would be it's really down to the nature of the nuisance. Let's say, for example, if there was piles of rubbish being left outside the property to the point it was becoming a health hazard. Again, that's something that could be quite easily determined and monitored because it's visible, it's there all the time. So I think it's case specific, really.
Have you assessed the impact that you might see in tenancies that seek to confirm increasing grounds for a breach of tenancy? So you mentioned parties, it could be literal vehicles left on the front of a property. Ultimately, is there a concern you have that those drafting tenancy agreements will be looking to seek more grounds for breach of tenancy because that's an easier potential contractual way to break a clause then? And is there a risk then to the tenant that they're living in a more restricted environment because of this?
Well, there is ultimately the backstop of the Petty Debts Court if there's a dispute over this. A landlord at any point in a tenancy can seek a mutual agreement from the tenant to end the tenancy and say, here are my reasons, what's your views? Tenant doesn't have to say yes. They can then go to the next step of looking to see if there's legitimate grounds for it. Serious breach is 1 month notice, whereas serious or repeated nuisance is 7 days. They can use their judgment as to that, and they can attempt to issue that to a tenant. And if the tenant thinks that it's not right, their backstop is to not accept it and say to the tenant, you'll have to say to the landlord, you'll have to go to the Petty Debts Court to have them test whether this is appropriate. So there's lots of steps along the way before you get to that.
Okay.
Okay. So just continue on that theme. So given the omission of statutory definitions of both a serious breach of a tenancy agreement and a serious or repeated nuisance, what risk does the Minister foresee in how these terms may be interpreted and applied by landlords, enforcement officers and the courts? And when will guidance be published?
There will be guidance. Someone will have to remind me when in the timeline that might come. My view is that as it's termed and the multi-stages that it'll take before getting to this, is that common sense will prevail from the first instances. If a tenant knows that it's a fair cop, they have done wrong and ought to be asked to leave, then if they've got any sense, they won't complain too much along the way about it. But if it's being used unjustly, there are several backstops along the way that they can avail themselves of to stand up for themselves. And ultimately, it'll be the Petty Debts Court who already have the expertise on eviction proceedings, as that's the body that deals with it. And they've been around the block a few times on this already, and will continue to do so under this law.
So in the hearing, the Minister confirmed an intention to bring forward regulations establishing powers of entry and investigation to allow the Regulation Directorate to undertake investigations under the new law independently without needing police involvement. Can the Minister provide more detail on the scope of those powers and the types of cases they are intended to cover?
So we're not going to start doing all of that until hopefully this law is passed, because the regulations won't be necessary if the law isn't passed. So that will be the period under which the depth of that is done. But if there's any preliminary things that have been looked at, either of my officers can indicate.
No, I think the primary legislation sets out what the regulation making power would include, and we'd look to draw from that.
Okay, I'm going to slip past a couple of these questions in that case. Yes. So I'm sorry, I think go past that one. Okay, so Minister, given that the law relies heavily on effective enforcement, do you accept that if tenants are not empowered to challenge evictions, or if resources are too limited to support enforcement, there is a risk that no-fault evictions could continue in practice despite their being unlawful under the draft law?
There may always be cases that slip through the cracks because of people, perhaps unfortunately not realising what rights they have and what bodies exist to defend those rights. But the backstop of the Petty Debts Court is an effective one. It's one that tenants can raise with their landlord early on in the process if they think they need to put a stop to something. A lot of that will be down to the tenant's judgment as to how far they think they can push on those things whilst maintaining a nice relationship with the person that owns their home. There'll be a lot of judgment within that, and some people will prefer to be more gung-ho and some will prefer to be a bit more passive in that, and that will be down to them. But the ultimate backstop now that the Petty Debts Court has, that it doesn't have right now, is that if notice is issued without a good reason, or a purported reason that isn't actually accurate, they will have the ability to not process an eviction. Whereas right now, under Article 6 of the Residential Tenancy Law, the reason is completely irrelevant. The only thing the Petty Debts Court can do is grant a stay of eviction, but they can't say that this is an illegitimate eviction, therefore it can't happen. Mm-hmm. That is a huge change that will be massively to the benefit of people who would otherwise be treated unfairly.
Thank you. Okay.
Minister, just keep you on this for a moment, because we're talking about the enforcement and this kind of expansion of the regulation for enforcement powers. My first question is: has any assessment been made for additional resources or capacity that is required to help expand these investigatory powers around this, and is it sufficient? Sufficient.
Yeah, so we've engaged closely with the Regulation Directorate throughout, and this is one particular area that they actually feel quite relaxed about, and that's simply because they do this work in shadow already. So they work with the States Jersey Police to provide them professional advice and support to compile cases. They receive queries in relation to tenants' rights and landlords' rights on a daily basis. So I think they see this as merely formalising their role and allowing them to complete their job, to bring forward cases, and where they've been unable to gather the evidence on a voluntary basis, that they can then take cases forward independently. So that it's for every conversation that we've had with them, they feel confident this matches into the work that they already do, and that they're able to.
So the letter we received from the Minister for
Yes.
Environment did specifically point out that this is a concern about the capacity, the resources, and the fact that they are all quite stretched already. And
So that was in specific relation to the expanded definition around nuisance. So, well, the altered definition around nuisance. So drawing off of the requirement to determine a nuisance. I say on balance of, on the one hand, it could give rise to a risk of more landlords getting in touch to seek that confirmation, if you like, from officers. On the other hand, I think they've also said it could make it more streamlined because this sets a benchmark of it being serious. I think that there is a bigger issue within the Regulation Directorate, which I think the Minister for the Environment, I know, certainly acknowledged, around resourcing at the moment. I don't think it's so much of an issue of headcount, it's more vacancy management and staff absence management, which is an issue I think that they are looking to resolve. But as far as I understand, and I did have a follow-up meeting with the Regulation Directorate following receipt of the letter that they sent to you, just to make sure that we did understand that the overall enforcement powers of the law is not what was intended by these comments, because that's more of a business as usual function as they see it.
So you're saying, just to make sure that's correct in my head, that it's not necessarily an expansion of powers under this law for regulation. It's more business as usual.
That's how they have described that situation to me.
Okay, and in that sense, it's an interesting one, because it's something that I think different stakeholders have had different views on whether that is an expansion or not. So it would be interesting to hear again from the Minister for Environment maybe about understanding that, because to say we received a different understanding with that. And so, yeah, it'll be good future. Right, so maybe to Deputy Curtis.
Now, we've touched on transitional period already, but the panel has some concerns about the transitional period between the law being passed and its commencement. And in our last hearing, you noted, as you've noted today, the significant amount of work. But perhaps we could take this point in time to have a little more, kind of clarity over kind of the particular, the most challenging elements you see within that period that will require further attention or clarification. And anything that's changed since we last spoke, that's arisen from either you assessing our scrutiny review, or likewise that will change, what's happening in that transitional period before enactment.
I don't know. I mean, that there are things that we know we'll need to get on with that we can't do now because the law's not been passed, it's at risk work, I think it's called. So we're going to have to come up with the rules for the rent tribunal, and we want to make sure those are good and robust and do the job. The regulations that we were just talking about for enforcement and that kind of thing, we'll have to do that. That will have to be debated at some point in the future as well. So, but all of this stuff we know we're going to have to do during that period, and we don't know what we don't know. But, who knows? Somebody might point out something in all of that makes us think actually we need to spend a bit more time on this to get it right. And there is, there's an election on the horizon, and PERDA that will come before it, and there's limits in what you can do during that time. So we'd ideally want to get it done before then. But there's risks at every point in that, and we've just got to try our best. And
one of the main elements that will have to transition if the law is passed is between pre-existing fixed-term agreements when someone remains in the property. The draft law says that the agreement will be treated as a periodic tenancy unless either party acts to stop that outcome at the point where it ends. Could you explain step by step how this implied continuation will operate in practice?
The same way that it does now, where it's possible for fixed-term contracts to be signed and then they expire, but the rent still keeps getting paid and people still keep staying living there. That's something that happens already in our rental market. It's happened to me before. And that would be the same in terms of the mechanics of that happening. It would just be at the point of it happening, the new provisions for periodic tenancies are what would take over rather than the existing provisions.
Okay.
Can I ask on that specifically, because earlier I maybe a misunderstanding, but you mentioned that in the transitional period that landlords could then start that initial fixed term and then the periodics.
Yes.
So just for clarification, so for example, if a fixed term was when the law comes into force, maybe there's a 3 months or 4 months left on a fixed term, a landlord could then do another fixed term before periodic.
Yes, yeah, but that fixed term would be under this legal framework, not the
Yes, of course, it's not that
framework.
the fixed term that they're currently on would be considered the first fixed term.
Yes.
There's
Yes,
another
that's
opportunity.
Right. Yeah.
So given there is that extra kind of bite at a fixed term, do you see any practical or legal challenges with landlords or tenants disputing that an implied periodic tenancy has arisen versus perhaps another side saying they wanted to, that they were trying to renew that final fixed term that they could have under transitional periods?
They could try, but I think it's relatively clear as it's posed, yeah.
Okay. Under the draft law, pre-existing fixed-term agreements will be allowed to continue until their natural conclusion for a period of up to 3 years, once a new law comes into effect, unless an agreement is varied. What threshold would qualify as a variation that results in a new agreement under the draft amendment law?
A different clause is negotiated in it. Either party at any point is allowed to go to the other and say, I would like to have this part of our contract changed. Can we negotiate that? And if they agree, then that's a variation. There are things that a contract will say that leave future things open, like, for example, whether they can have a pet or not. And later on, a landlord or tenant choosing to go back to that clause and invoke it, I don't think would count as a variation because it's already accounted for in that initial contract. So I think it's reasonably clear that it'd be a material change in what a clause says, or that the contract in force would look different to the one that.
Do you see any threshold to that? Would something like changing the payment date count as a variation?
Good question. I kind of think it would, but is that right?
Yeah, if there was nothing provided for that would allow that flexibility in the contract, then technically it would be a variation.
A variation that would qualify under the laws. Okay. And I think we've felt from our feedback that the transition from existing fixed term or periodic tenancies to the new framework may well be a hotspot of misunderstandings, particularly around rent resets, notice periods and implied periodic tenancies. So what specific safeguards have you built into the draft law or will be issued as supplementary guidance to minimise disputes?
Well, if the law's accepted in the terms that we hope it is, we will have to do a communications piece to say to people, this is coming, these are the change, and if your tenancy looks like this is what will subsequently arise from it. The more effective we are at that, the more we mitigate those chances of misunderstandings or people not quite getting there. You can't get to everyone, and there will potentially still be people for whom this goes completely over their heads and they don't know about it. And it may well be that it only arises when a problem comes up, but then they would have to go and look at the law and perhaps get advice on it and ask how it applies, and they would then, that would just be that. They'd have to abide by that.
Do you see any scope for guidance, supplementary guidance that goes beyond communication that would help soften this period?
That will be part of the big package we end up doing, yeah.
Just on that communications piece, because I noticed you took someone to task in the Jersey Evening Post the other day about their interpretation of the new laws. I mean, there seem to be a lot of preconceived ideas around what you're doing here. How are you mitigating that? How are you managing to communicate? Is this sort of a hardcore people who just aren't interested in listening, or is this? Why do you think there's so much noise and around what you're doing?
Deputy, because I'm challenging vested interests.
Okay.
That's why, and vested interests don't like that. There are people out there who simply don't want any kind of extra law that says what they can and can't do. They would prefer for them to be able to get on and negotiate things without any overseeing or anything like that. And those people have an old school view that I think is completely out of place when we're talking about something that is not an ordinary commodity, it's a human right. That's political. Some of those people are lost causes. I'll never win them over. But just because that there's a hardcore of people who have yet to wake up and smell the coffee doesn't mean that we don't try to do what's right. But I will take no prisoners in my communications approach when I think misinformation comes forward.
Thank you, Minister. I'm about to go on to wider questions on engagement and communication, but first I want to just... No, okay, so Deputy Coles.
Thank you.
Carry on that.
Perfect. The panel has received over 290 responses to its review from a broad range of stakeholders, including private landlords, estate agents, businesses, associations, charities and tenants. Tenants were specifically targeted through a dedicated survey provided in both English and Portuguese. Alongside this, we've held 4 public hearings, 4 community pop-ups, 2 of which took place in Portuguese-owned businesses with the support of a translator. In light of this, can you outline how tenants, including those from harder-to-reach communities, were engaged during the development of the law? We're keen to understand your experience from that process and whether that has reflected in its accessibility and effectiveness.
Mm-hmm. So that's a very big question because this work has been going on for a long time. I was Housing Minister when the Housing Policy Development Board all those years ago originally started drawing up these proposals, and some of that work was done during COVID as well. So all of that had an impact on that. There was a big consultation in 2023 that had various opportunities for people to involve themselves and give feedback on it. Those multiple exercises already having been taken, and of course the minor matter of an election in 2022, on which this was a big part of my platform on the doorsteps. I, since retaking the position of Housing Minister, chose to be a lot more focused in my engagement rather than redo another big, massive consultation exercise. That ranges from specific engagements with specific organisations. That has been an informal coffee in a cafe to understand their perspective, to a more formalised structure in a government office with minute takers and all the rest. And my personal conversations with constituents who come to me very regularly with problems that they encounter, and I bank them and factor them in when I'm trying to find solutions and trying to propose law changes that might deal with those situations. But the consultation has taken many shapes and forms, but it's gone on for a long time.
Okay. During the panel's hearings with Caritas Jersey, we heard concerns about individuals who fall outside the scope of the draft law, particularly those without formal tenancy agreements, often living in conditions that would likely render a property uninhabitable. How does the draft law improve protections for tenants, if at all?
So, well, it does axiomatically by the fact that we're abolishing revenge evictions and introducing a form of rent stabilisation. And for those who have tenancies covered under the current residential tenancy law, they will have an enhanced framework and ability to stand up for themselves. That is objectively an enhancement for those. It is the case that this law doesn't cover every single permutation of housing offer for different types of renters in the islands, including lodging, for example. And I can be clear about politically why I made a decision for this law to focus in just on the type of renting arrangement that it does. And it's because I thought that this was feasible to deliver in this remaining term of office. Had we attempted to go further on it and bring in all sorts of other living arrangements, and we would have ended up spending, I think, probably years chasing our tail and not improving anything for anyone in the meantime. So this law, if it gets over the line, will start benefiting people. The alternative was to spend a lot longer and end up benefiting nobody in the meantime, and potentially nobody at all if the project ended up failing in the end. So I accept that once this work is done, there will need to be some kind of piece of work done on those other kinds of living arrangements that aren't caught under this.
But it's more this fact with people without formal tenancy agreements at the moment. There's nothing provided within this these draft amendments of the law.
What instances do you mean by that?
So if somebody hasn't been given a contract of tenancy, there's nothing been signed, there's been no paperwork issued to the tenant.
So that would be a breach of the existing residential tenancy law. When we listened in to the Caritas, I think the first thing that was coming to me is we need to work with Caritas and other agencies who are learning about landlords who are not following the existing legal framework that applies to them. And that is both in relation to residential tenancy law and things like the Public Health and Safety of Rented Dwellings law. They're both flagging as a compliance issue from that conversation. So hopefully, even just by raising the profile of the legislation of itself, irrespective of the changes, landlords and tenants will be more aware of their legal rights and obligations.
Perfect, thanks. So as a deputy will cover my next question, so I'll move on to my last question of this section. Will the Housing Advice Service act as the first stop service for tenants or landlords who are unsure whether a breach has occurred or the need to support understanding of the draft law? If not, what service do you expect to fill this role?
Well, I don't think there's an automatic designated first stop, because people will have different places that they prefer to go to as their first step. You know, if you have a landlord with a large portfolio, they might be more frequently in contact with their lawyer than somebody who maybe only has one property. So they might prefer to go to their lawyer as a first step, and that's perfectly legitimate. You might have people who are more tied into a charity that represents and supports them, and that's perfectly legitimate for them too. But our housing advice service, it exists to be a point of contact for anybody who wants to go there for it and thinks it can be useful, and they have the ability to open doors to other government services, etc., if that's needed, and help build packages of support around people. So they'll be really useful, but people are perfectly free to go to another body if they would find that more appropriate for themselves.
I suppose one of the main factors of this question is more around whether or not they will be able to provide a service to both the landlord and the tenant.
Oh yes, yeah, absolutely, and I absolutely encourage landlords to engage with the housing advice service. That it exists as much for them as anyone else too.
Okay.
Thank you, Minister. And just in the last 15 minutes, we're going to go on to secondary legislations. So, Minister, would the revocation of a landlord's rented dwelling licence under the Public Health and Safety Rented Dwellings Licence regulations be captured under Article 9(1) of the draft law as a situation in which a residential unit is considered to become uninhabitable? Mm-hmm. So when a licence from the dwelling licence is then revoked, would that be considered when you say uninhabitable?
Yeah, I believe so. Mm-hmm.
Can you clarify how that determination would be made in practice, and whether the tenant would then be entitled to end the tenancy under this ground?
Mm-hmm. Well, I think they would be entitled to do that. There are different bodies that can make that judgment, environmental health being the lead one.
Yeah, so under 9(1)(a) to C, it defines it could be the insurer, could be the fire and rescue service, or an administration of the states who makes that determination. So it depends on what the cause of the lack of habitability may have been. If it was something that relates more generally to public health and safety rented dwellings legislation because of damp and mould, for example, or it could have been a fire, or severe subsidence that has rendered the building unsafe. So the relevant body would make the determination. It could be one, it could be all three, depending on the circumstances.
Okay, and it's and so it's clear in the framework of the draft law that this is from both sides, is that if a licence is revoked, then the tenant has able to. The panel has heard some public confusion around what other laws, policies or guidance may be affected by the draft residence or tenancy law. Can you confirm which other pieces of legislation, primary or secondary, you anticipate will be directly or indirectly impacted by its approval?
Well, some of it will be repealed as a result of its approval. Some of the old 1940s law will be done away with as a result of this. There's a schedule at the end of the law that says specifically what other laws face amendments because of that. I can't remember if that's just repeals or if it's changes.
I think it's very
if there is a
limited.
schedule in the law, yeah, it's very limited.
Very
yeah.
limited. I don't think
Consequential
amendments. So
amendments,
under the agricultural loans regulations, relating to rents payable, quoting the updated legislation, and similarly in the building loans law, in relation to rental payments, quoting the correct legislation.
And this is direct, but is there any indirect? Has there been that kind of analysis of that links with indirectly other laws?
I think one of our key focuses when developing the legislation was to seek greater alignment with other laws where there may have been some drift. So I think it was recognised in particular with the Public Health and Safety Rented Dwellings Law that some differences in definitions leads to complexity or lack of clarity when coming to enforce the law. So we've tried to account for that as far as we can, but I don't know if maybe Tim online has anything else he would want to add.
Yeah, I mean, I think any of those provisions that reference other legislation, we have analysed and been in contact with the relevant officers. So, for example, when giving 7 days notice around someone who does no longer have a work permit, we made sure that we understood what the practices were on that side in terms of the policy to make sure that that was a proportionate piece of proportionate provision. So, we've looked at that. We've made sure that if someone loses their status under the Control of Housing and Work law, that the amount of notice that we are providing for that reason is consistent with the practices under that legislation by talking to the officers. So we have looked at a number of different pieces of legislation to make sure that our law doesn't impact it in a negative or unintended way.
There's one that, and I definitely am not an expert in this, so it comes from just the submission from the Law Society subcommittee where they said there could be an impact like with contract law because of course ultimately we're talking about contracts between two parties. Was that looked at all, or is anything within that could overlap in any way?
Contract. We don't have a law that says this is what Jersey contract law is, and it's quite common that you'll have pieces of legislation that imply terms into contracts, and this is what this law does and what its previous iteration did as well. So yeah, that's quite normal.
Thank you. And you're just talking about the work permit holder, and under the draft law, would a work permit holder who's required to leave Jersey for 3 months, for example, but due to conditions of their permit, but be considered a new tenant when they return?
Yes.
Okay. And then this means they could have a new fixed term.
Yes.
Thank you. The draft law, Minister, gives you wide-ranging powers to make orders. Under Article 23, for example, you may make orders excluding the requirement for the chair and deputy chair of the tribunal to have a qualification in law. Why might you need such a power?
That I think is a just-in-case clause. It's we're setting up, or hoping to set up a rent tribunal with a membership. We've looked at the other tribunals and how those work, and tried not to have too many differences in that. So there's synergies across the board there. But if in 5 years' time it turns out that actually maybe the tribunal would be more effective with a minor tweak to it, that a future housing minister would be able to sign that off. It's not for any preconceived direction of travel on that. It's a just-in-case clause.
And you also have power to provide for the procedures of the rent tribunal. Could you commit to the proposed procedures being published at least in draft by the time this is debated?
This draft law?
Yeah.
No.
So the State Assembly would not know what
Yeah,
was
and that's
being
perfectly
used.
normal. You wouldn't do that, and that would very much be at-risk work, because we don't know whether the Assembly will actually approve the existence of a tribunal. But they will be available before the tribunal comes into being and starts operating, definitely. And of course, I would show that with scrutiny as well. That's obviously something we'd want your feedback on.
Yeah, and just in terms of that timeline that we were just talking about earlier, because we're focused on developing that in the period before the law is enacted, I expect there will be a point in time that you can see a draft. It will just be after the debate has taken place, but before the law is enacted.
Yeah.
Okay, thank you. And just in general, as drafted, the powers are quite wide-ranging under orders. Are you envisaging making any more, or what are you envisaging that the future housing minister could use under Article 23?
No, none specifically. So the order making power that I'll have, some of that is for the necessary implementation, things like the commencement of the law itself, and that will be a matter of judgment at the time whether we are ready to enact it or not. The procedures for the rent tribunal, some of the, and those are just in case, because we'll want to see how it proceeds and how it actually works in practice and how it's used. But I don't have any preconceived ideas of what those orders might specifically be used for. It's just we don't know what the future holds.
No, but do you accept that the order making is quite wide ranging, the powers to make orders? So if there could be in the future, future housing minister could do many other kinds of orders.
I kind of don't, to be perfectly honest, because I think they're relatively specific at what they would be. And I don't think they really change fundamentally what the law is about. I'd actually argue that the current residential tenancy law has some order-making powers in it that are more wide-ranging in this. In fact, there'll be order-making powers that I'll lose in this law. I currently have the right to do an order changing notice periods for periodic tenancies. I could sign an order tomorrow saying the notice period is 24 months. And then get lynched as I walk out of the office, no doubt. But I will lose that power in this. But that's a more fundamental kind of decision, whereas these are more about the specifics of things. They're not really fundamental issues. Okay. So they might be numerically more, but less significant in their material impact.
Okay, thank you. Just turning to advisor if you've got any questions. Okay, well, the final few questions. Minister, the report accompanying the draft law estimates 130,000 in funding, principally for the rent tribunal member remuneration and administrative support. No reference is made for financing or staffing implications for other departments. However, the Minister of the Environment has confirmed that additional resourcing could be needed for enforcement. Judicial Greffier has indicated further funding may be required to support the tribunal. Committee to Connatals have mentioned resource implications for the honorary police and parishes, and the regulation director is also like to require extra capacity. Do you consider 130,000 to be a realistic estimate? And if so, why are these wider resources implications not reflected in the report?
So I think that these resourcing is... I think I veered actually more towards the pessimistic side for seeking this. There's a significant amount of funding that already exists in budgets that can be reallocated to this, down to the very prescient decisions of a former housing minister and getting future funding allocated for the eventuality of this. There is that great unknown of how many cases will come to the rent tribunal, and that will have an effect. If it's completely inundated, that would be a surprise. I think we've been a little bit pessimistic in that. I don't think the tribunal will have that many cases coming forward, in which case it would end up under budget. Regulation does have some difficulties at the moment with staffing and resourcing, and they're working through to overcome that. But when they have the certainty of whether this law is being enacted or not, that will help them internally manage who's doing what role and who's focusing on what side of that. So I'm content that it's manageable under current processes.
Okay, so you don't believe that there needs to be more resources put in the budget, in the future budget, for example?
No, I'd be very surprised if that were the case, and part of that is a consequence of the fact that the proposed law is very passive in what it's proposing. It doesn't require hardcore enforcement on every single aspect of it on a day-to-day basis.
I suppose my last question on that is, because the list that and the letters that the submissions we've received from different stakeholders that I mentioned obviously fall under different ministers. Have you had discussions with the different ministers on this to reassure them, and are they supportive of this regulation from that regard, that they don't need to also find more funding to support them?
I mean, from me directly, that's not been a huge part of the conversation. The conversation's been about politically whether this meets the different tastes of the different members of our coalition.
Yeah, I mean, at the officer level, no significant concern had been brought to our attention around the capability to manage the changes in the legislation. I think there is a context, as you say, particularly with the housing and nuisance team, that they do have some resourcing challenges at this moment in time. There's also a slight, I would say, peculiarity or nuance that the officers of the housing and nuisance team are the Minister for the Environment officers, but they're also the Minister for Housing's officers. So it's a shared resource in effect, and where do you draw the line on the sharing of that resource is possibly a question to be asked as well. It's the challenges of sharing specialist officers. But to date, I think we haven't had any major concerns. The focus has been on the tribunal because that is establishing a new service. And there are lots of things in the law that arguably could decrease pressures, like through the modernisation of the legislation, the commitment to the publication of new guidance. That of itself should reduce the number of inquiries that are made where people are unsure about how the law may or may not apply to them. I think the Minister makes an important point that it is always impossible to absolutely determine what resourcing implications may come from any legislation, and we also have to be cautious to not grow the head count of the public service based on a possibility that there could be some additional work.
Thank you. And Minister, just for clarification for us, but also for states members as well, coming towards the 8th of July, will you be taking the different amendments separately in the debate or to vote on, or will it be?
I haven't yet asked for a specific breakdown of what's possible to take separately, but it is my intention, as far as is possible, to do that. I don't think it's going to be possible to take the periodic tenancies and rent stabilisation separately. I think they have to work together. If you don't have one, it causes great difficulties with the other. So that will be a struggle. But the other elements, I will try to do so. Yeah.
Thank you. And this weekend in the newspaper, the Chief Minister talked about this kind of three-tier kind of Council of Ministers three-tier decision-making. Where would you say this regulations or future regulation potentially sits within that three-tier?
This is so embarrassing because I didn't read it. I didn't
Triple
read
check.
that.
It was a triple check. So in other words,
check. I can't tell you right now who's in favour and who's against, because some members will still have open minds, and there'll still be some who I might need to work harder to persuade. So I don't know exactly where it is, but the Chief Minister has indicated that if there are ministers who really strongly object to what I'm doing, then they will be able to vote according to their conscience, but with a no surprises policy. So I should know that walking into the chamber that morning.
Yes, I think that's number 2 on the list of that. Well, thank you very much, Minister. I'd like to just put to my panel if there's anything further, advisor. So wow, we have 1 minute, I think, to go. Looking at the clock, and I'm amazed that we've got through all those questions. So I just maybe, Minister, if there's anything else you would want to, if we haven't covered from our side, because of course, this is our last hearing before we start the important task of writing a report.
No, I don't think so. It's just to reiterate that if there's any outstanding questions or anything that arises from it, please get in touch with us as soon as possible, and we'll try to answer them as quickly as we can.
Well, thank you very much, Minister, for coming. Thank you to Officer as well, and thank you to the support team.